Hi, I'm Nevada licensed debt adjuster Damian Falcone. This video will be the first in a series about consumer debt collection. In this series, we will discuss what debt collectors can and cannot do, your rights when dealing with debt collectors, and what to do when collectors engage in illegal activities. This is Get Settled, your source for consumer debt settlement information. As always, for even more information, go to www.nceds.org. Consumer debt collection is governed by a federal law called the Fair Debt Collections Practices Act, or FDCPA. The purpose of this law is to eliminate abusive debt collection activities. First, let's talk about who is governed by the law. The FDCPA only applies to debt collectors and not original creditors. So for example, if the bank where you originally obtained a loan is attempting to collect on its own debt, this information does not apply. But if the debt has been turned over to a collection agent or a law firm, they are bound by the rules we will be discussing in this series. We have interviewed a former collection agent that has asked that we conceal his identity. John was a collection agent in the state of New York. As a collection agent, John had a different view of these nationwide laws and has agreed to tell us about his experiences and past behavior.
My collector's name was John Perkins. Astor Perkins Pancake House.
The Act prohibits numerous abusive and deceptive tactics when attempting to collect a debt. For example, although a debt collector can make phone calls to you, they cannot call you at unreasonable hours. Generally, that means they cannot call you before 8 a.m. or after 9 p.m.
A lot of times we would call outside the legal calling hours and people would complain. And then I would just turn around and say, well, in my time zone here, it's legal for me to be calling. Are you telling me you don't feel you owe this debt? Doesn't matter what time I called. You owe a debt.
They are also prohibited from making calls to your place of employment if they've been told that you can't take calls at work.
If they were at work, they would complain that they can't take phone calls. And then I would tell them, look, I'm going to give you one chance. If you don't call me when you get off work, I will call your place of employment every day. And that really would be a leverage, and it worked out well.
In addition, debt collectors must not call you if you are represented by an attorney or if you have asked in writing for the calls to stop. For documentation purposes, I provide a checklist in an upcoming episode of things to look out for.
I never dealt with lawsuits. Once I turned it over to the attorney, it was out of my hands, and I went on to the next client. I went on to the next debtor.
Even when a debt collector is allowed to call you, there are several things that they cannot do in the process of the telephone conversation. In general, collectors are prohibited from using harassment or abuse. This means they cannot threaten you with violence, use obscene or profane language, threaten to report you to any government agency, or threaten arrest or a lawsuit if it is not actually contemplated and legal to do so. Debt collectors also cannot contact your employer or most other third parties about your debt.
A lot of times we weren't allowed to tell a second party, a wife or something. And if the wife answered the phone, then I'd say, well, look, we need to contact your husband. If I could cause problems within the relationship to be able to settle the debt, the more chaos I created, the faster I got my money.
In addition to mapping out the prohibited practices that we have talked about, the FDCPA also states numerous things that debt collectors are required to do. At the outset of the collection efforts, a collector must send you a letter notifying you that you have 30 days in which to dispute the debt. If you dispute the debt within this time period, they must cease all collection efforts until the details of the debt are verified. In an episode to follow, I show you how to write a standard dispute letter.
If it wasn't certified, it went in the garbage. And most of the time, if it was certified, it still went in the garbage.
In addition, they must identify themselves in every communication and let you know that any information that they obtain from you will be used in their collection efforts.
If you ask someone what the Fair Debt Collection Practice Act was, they wouldn't know what it was all about. That's where we had the upper hand.
If their attempts to collect fail and no settlement is reached, a creditor can file a lawsuit against you, either in the place where you live or the place where the contract was signed. I will show you what a filing looks like and what you will need to do in response. So let's review. Federal law allows debt collectors to contact you, but has provisions in place to stop abuse and harassment. The more you know about these prohibited activities, the more success you can have in negotiating with collectors to resolve your outstanding debts. In our next video, we will discuss your rights when dealing with debt collectors and how knowing your rights can put you in a better position to get your debt resolved. I'm Damian Falcone, and this is Get Settled.